Hello student, let me explain the concept of bail under bnss, right? So let's start. See, yes, definition. The word bail itself comes from the old French word bailer, meaning to give or deliver. Yes. So give or deliver. It came from the French word. It means bailer. So what the bailer means? To give or deliver. So next point is section 2b, right, of the bnss. So what it is defining means it is defining the term bail. So how it has defined means it is the release of a person from the legal custody, right? That person may be an accused or often suspected of an commission of an offense. We are only suspecting him that he has done so and so offense. So he is having the right, not right, he is having the right to release from the custody, but upon the certain condition that may be imposed by the court, yeah, that may be imposed by the officer, right? And there will be the security, okay, that may be a bound, that may be a bail bound, yeah, security of a person. So based upon the security only he will be released from the legal custody. So next is Black's Law Dictionary describes bail as a form of security. Yeah, bail is a form of security, typically money or bond, required by court for the release of a prisoner who must appear at a later date. So here Black Law Dictionary, what it defines means bail is a form of security. Maybe security may be of a money or it may be a bound of the property. Yeah, it may be a third party security as a person, right? So required by court for the release of the accused who must appear at a later date. Like later date means whenever there will be the hearing, he has to appear, okay? And also 15 days in a month, 15 days he has to go and give the attendance in the so and so police station. So he has to go and sign the attendance, okay? And next is types of bail. So types of bail means offense are classified for bail purpose into. So generally we have two bail, right? Bailable offenses and non-bailable offenses. So bailable offenses, it is defined by section 2 of bnss. These offenses allow for bail as a matter of right under section 478 bnss, right, when specified conditions are met. The police may grant bail to the offender at the time of the arrest or detention. So bailable offences now it is defined under the section 2 of the bnss. So here the accused will get easily bail because it is the matter of right here. So he is having the right to get the bail, right? Because under the bailable offense now the accused will be committed a very minor offenses, petty offenses, not serious one, not heinous one. Because of that here what happens means the accused will get easily bail, and even the police is having the power to grant the bail because it's a matter of right. And only for the minor offenses the accused will be getting the bail, that is the bailable offense. And non bailable offense means here these offenses where bail cannot be granted as the matter of right. Yeah, very difficult to get the bail because accused has committed very heinous, very serious offenses like rape, murder, kidnapping, dacoity with murder, right? Very heinous, very serious offenses. So usually here very difficult to get the bail, and it is governed by the section 480 and 483 of the bnss. And its discretion is left with the court whether to grant the bail or whether to reject the bail. Only it is left to the court. Only magistrate is having the power to grant the bail to the non bailable offenses. So if you see bailable offenses now, the police having the power, But in case of non-bailable offences, na, here police will not having any power to grant. Only magistrate is having the power to grant, and it is the discretionary power of the judiciary whether to grant or reject the bail, because non-bailable means very difficult to get the bail because they have committed a very heinous crime. And next is regular bail. So regular bail is the most common type of bail applied when a person has been arrested and is already in police custody. It's a common type, right? And he will be applied when he has been arrested and he is in police custody and still the charge sheet has not filed, right? So example, if you are accused of an bailable offense, you have an absolute right to be released on bail at any point during the legal proceedings. Yeah, so you have an absolute right to be released on the bail at any point. This is statutory right, meaning neither the court nor the investigation officer can refuse you bail. The police officer has a legal duty to grant you bail if requested. So, regular bail is common type of bail and it can be applied, right? And when a person has been arrested and he is already in the police custody. Okay, and next is anticipatory bail. Anticipatory bail means it is the direction to release a person on bail issued even before the person is arrested. So here in this case, accused now he will not get arrest, but he'll be having the fear of getting arrested and he want to avoid that. So what he will do, he will abscond, right, from that place, and indirectly he'll engage with the advocate. So from remaining outside the court, the accused with the help of the advocate, he can take the bail, right? That is known as anticipatory bail. But he has to prove that whatever the charges, right, whatever the allegations are made against him, na, those all are false. Then only the high court and session courts are having the power to grant the anticipatory bail. And next, interim bail. So interim bail is granted for the short period, right? So short period only it is granted, because when the accused is not getting the regular bail, then however he can get under the bail under the interim bail for the purpose of medical emergency, or somebody died in his home, right? Yeah, somebody is serious, right? So if there is an emergency, then he can get the interim bail, only short period like 2 weeks, 3 weeks, 8 weeks, right? He can be released from the custody. And next is medical bail. The bail granted to a person purely on medical grounds. So as the name itself indicates, purely on the medical grounds is called the medical bail. Next is case law, Sangeeta Bhatia versus State of NCT of Delhi. So in this case, it was decided anticipatory bail as a statutory right. Anticipatory bail is a statutory right, right? The court shouldn't ignore, right? I mean, it is a matter of the right of the person, and based on hearing, the court should grant the anticipatory bail. Mohammad Jubair versus State of NCT of Delhi. The Supreme Court of India granted interim bail to the accused and also imposed certain condition with it. Yeah, so in this case, uh, court has granted accused interim bail and with certain condition. Yes, there will be the certain conditions, right? Without condition they will not grant the bail. So what will be the condition means, whenever the court will ask him to appear, na, he should appear. One second, he should not travel, like foreign trips, foreign tour, right? He should not travel. If you want to travel, na, then he should take the permission of the court, right? And every 15th day in a month, right, he should sign the register of the attendance which is there, I mean, which is there in the police station. So he should go to the police station and sign the register, Okay, so these all are the condition. Next is NS Sahani versus Union of India. The Honorable Supreme Court held that the court has the discretionary powers in the matter of anticipatory bail, and it is not an essential part of a right to life under Article 21. So NS Sahani, what they in this case what happened means the Supreme Court said the court is having the discretionary power to grant the anticipatory bail. Discretionary powers means it may reject the bail, yeah, it may grant the bail. It is left to the magistrate, right? And it is not the matter of the right under the Article 21. It is not against the Article 21. The court is having the discretionary power whether to grant or not to grant. That is decided in NS Sahani versus Union of India. Thank you all.